are on live stream number 2 today. Let me give you a little, and I'm bouncing around. I'm listening to these really loud VTA buses that are completely empty, and they're running the air conditioning, and the train's coming. So anyway, I'm here at the courthouse. The jury is, let me get the things out of my eyes. The jury is hearing closing arguments from the attorneys, and so I came down to the courthouse to talk about what's going on in the courtroom. I'm in front of the older courthouse because, as you know, the judges have been making all these dodgy little rules about we can't record on the property of these other courthouses. So I'm going to show you the courthouse where this trial is actually taking place, because it's across the street from the, and we're going to catch lawyers. I'm just trying to catch them in my live stream, because you guys all call me later on and say, oh, that was so-and-so, or you're catching some of these attorneys and people that I might not recognize. So I'm going to wait till people get in and give me a thumbs up that the sound is okay. These noisy buses are finally moving. And this older courthouse, I call it the ugly courthouse, the one with the flags way over there, that's where the trial is taking place related to Mark Erickson. And so I'm going to tell you what happened this morning according to court observers, because as you know, I'm not in that courtroom. But apparently this morning, the judge first ruled on another motion in limine. And motions in limine, again, are the motions that people file, attorneys file right before trial. And the motions in limine tell a judge and the attorneys, the judge rules on it, and it tells the attorneys what they can talk about and what they can't talk about in the trial. And so the first whammy to the plaintiff, and remember the plaintiff is Mark Erickson's former client. He's an 81-year-old man, and Mark Erickson did what we call threw him under the bus. Big loud bus like the ones that were out here a few minutes ago. And so the jury trials, we've just never seen a case go to a jury trial about an attorney committing malpractice, fraud, and everything else. And what the judge did in this case, and this is where we get to unfairness in the courts. If you have the money to get to trial, and you have the time, because it's taken 5 years for this case to get to trial, and you are able to successfully start the lawsuit against your former attorney, and you pay all the money, it's not a little bit of money. I'm going to go over the court reporters cost $2,200 a day, and that doesn't include the cost of the transcripts. There's court fees that they make you pay for the jury to be there. I'm not really sure where that money goes. Probably went to that secret bar bench media police club all the judges were involved in. But the people involved in the litigation have to pay those costs. And the attorneys have to make sure those costs get paid. There are depositions, and the reason they take depositions before a trial is because they don't want to consume court time, the hours of testimony. And in California, you can get a deposition in any lawsuit. We see them done in family court cases, civil cases. I don't know if you can do them in small claims cases, but the depositions in California, a few years ago, they limited the time that you would have to sit for a deposition to 8 hours. So I'm always amazed in family court cases how many people get a deposition, how many don't. It's very costly. Sometimes you can get the court reporter to do a video transcript, and we did one of those against the divorce attorney Brad Baugh that I was talking about earlier this morning, and they busted him on that video with his stolen valor claim. And what's nice about video depositions is you actually can see the person's face, you can see their eyes, you can hear the tone in their voice, whereas a written transcript, we can't hear any of all of that. And that's why I push for cameras in courtrooms, because even transcripts don't really show a true picture of what's going on in the courtroom. I've had a number of court observers note that the court reporter in the trial today is giving dirty looks at one of the parties. And I find that a little bit interesting. The jurors' faces today. They were rather disgusted when Mark Erickson testified. Apparently, he didn't sound very credible. He was trying to justify why he hadn't done certain things for his client who paid him a lot of money. And so whoever said, any person can video a depot, you don't need to be a parasite, cottage industry videographers. I think you actually have to get certified. There's some kind of thing in order to make it formal, and they make a lot of money. Those video depositions cost a lot of money, but it reinforces why we need cameras in courtrooms so that you can see what's going on, the gestures, the facial looks, the eye rolls. There are a lot of cues, and really good lawyers know how to use those to their advantage because they know how to poke away. They also know how to ask a question that might not be allowed or might be objected to, but they get it in the record, and the jury hears it. And when I was thinking about all the jury trials that I've covered and the ones that I've heard about, and I listened to the lawyers talk about the jury trials, it reminds me of an old criminal defense, or old prosecutor who turned family law attorney but had worked as a prosecutor for a while. And he told me one time that there is about the drunk driving tricks that prosecutors did. And what they did was when the jury came in to be seated, the prosecutors would, when they're screening the jury, they ask them a number of questions. So people can be excused for various reasons. Lawyers, police officers usually get excluded, and they try to look for things where you would be naturally biased as a juror, and they try to get rid of those people. And each side has so many exemptions where they can strike a juror and not give a reason. And once they're out of those exemptions, then they have to go back and they have to ask for permission. They're going to try to excuse a juror. They have to have a really good reason, like a disqualifying reason. And so in the old Santa Clara County District Attorney trick on drunk driving is they would ask a juror who might know the chief of police. And this is how juries tend to be very blue friendly. They like police officers, they're voters, they're residents. They are very supportive of police officers because they're the ones that the police officers come from. They don't typically watch YouTube and watch police videos. They might have been watching it related to ICE because they're the ones that are out protesting. But the average juror is going to be a resident, and that's how you get, or registering with your driver's license, you live in the area, and you're going to come down. You might not know anything about the court system, but you know things about life, getting tickets, being a parent, being fearful of drunk drivers, injuring your family, and that kind of thing. So this is how the prosecutors exploit that. The prosecutors in Santa Clara County had a pattern of what they would do is they would say to the jury, oh, have you, if you were to find out that the police chief wasn't telling the truth, if you were presented with evidence that meant that they were not telling the truth, would you be able to be fair and rule against the police chief or recognize that they weren't being credible and that you would have to dismiss their testimony? And all the jurors say yes, yes, yes. And then they get specific because they know just enough about a community. And so what these prosecutors used to do is they used to say, oh, so if you heard that police chief X from Los Altos was doing something wrong or lying, would you believe it? And then you would have a juror say, no, that police chief supports our kids' baseball teams and they're a pillar of the community and I see them out here all the time. And so you're listening to a juror give an endorsement of the police officer. And even though that juror gets excused and leaves, the remaining jury pool hears that, and it's very prejudicial. It seeps into the consciousness of all the jurors. And so what's at the center of this case, the malpractice trial, it's, again, the first time we ever know of a divorce attorney, private judge related case going before a jury. So these are jurors that, like many of you out there, never heard of private judging, never heard of any of this. And so at the beginning of the trial, the questions were, would you ever sign an agreement where you didn't fully read what that agreement was and you would just sign it? And all the jurors said, oh, no, I would never do that. I would, blah, blah, blah. And then the next question was, have you ever accepted a terms of service on your Apple phone, on your Netflix account, on your Facebook account, on any of the big businesses out here that have these mandatory arbitration agreements in terms of service? And the jury laughed. Pool. It was a room full of a lot of Silicon Valley tech people, and they all laughed because even though everybody knows their job and they know they're supposed to do it, when you're thinking, hey, I just want to use my phone or watch this Netflix movie, you will be inclined to just click I agree. And you don't always know what you're agreeing to. Well, what's at the center of this case is the man who hired Mark Erickson to protect him from the gold digger wife. The gold digger wife who was allegedly stealing gold coins from a safe involving her first husband to cheat the heirs out of their rightful inheritance. So we're dealing with a person where the divorce attorney should have been on heightened alert that this client could be being had. He was elderly too, so he was vulnerable. He had lost his children. His son died in a motorcycle accident. His daughter died of ovarian cancer. He lost his mother when he was young. But these are things that we all have that we bring into the courtroom with us, that we're not perfect human beings. Life happens to us. And what happened in this case was this man paid and trusted his attorney. His attorney first convinced him to use a private judge, which was just another attorney. And then he did very little work. I don't think he did any, according to his billing statement. And he testified today that he didn't do any work from the time period they went to the first judge session to the one they went to the one in question. And when they went to the one in question, there was no court reporter. It was a settlement conference. There had been no drafts back and forth between the attorney and the client about this is what you should be considering before you settle anything. These are the tax ramifications. These are all the issues that could be in play if you sign this settlement agreement. And so somebody's waving to me. I don't think they know I'm live. And they're going to be sorry if they walk up on me. I tell everybody, don't walk up on me on the courthouse if you don't want to be on camera. So they go to the private judge session. And the two attorneys, Mark Erickson and David Patton, go into the back with the other attorney who's playing private judge. And again, the words for private judge: temporary judge, private judge, rent-a-judge. Just think fake judge. This person could never have been an attorney. Never have been a judge, had no training on what to do, have no idea. It'd be like pulling that bus driver off the bus and saying, hey, could you come on in here and be a judge in this case? And attorneys really have had no training with judges other than dealing with them when they're in court. And so the attorneys are in the back talking to the private judge, and that is when this so-called term sheet must have been made. And the term sheet was an agreement, but it was labeled term sheet. Nobody understood what it was. And when the private judge and the client's attorney, Mark Erickson, came out, they went into a conference room by themselves. The ex-wife, the gold digger wife, was sitting in the lobby with David Patton. And while that was going on, Michael Smith, was the private judge, was trying to convince Mark Erickson's client that this would be good for him. He could stay married. It'd be like a post-nup. And he needed to sign it because he said that, oh, your wife still loves you. Well, if someone's vulnerable and they're in their mid to late 70s and they're worried about being alone in life, they've lost their children, that's a vulnerable moment. And that's when you need your attorney to really protect you. But Mark Erickson supposedly sat behind the client and said nothing. And after he signed the agreement with the pressure from the private judge, he said, I can't believe you just signed that. And evidence of that is that 6 or 8 months later, he filed a motion to set it aside, saying that his client had been coerced and it was fraud the way that he signed the term sheet. Well, if it was coercion, he was sitting right there. Why didn't he get his client and walk out? Why didn't he explain it to his client? Why didn't he stop it and say, look, this doesn't have to be signed today. There's no deadline. This is a private judge. It's not mediation, and you can sign it tomorrow. But he didn't. He let his client sign it, and then he said, I can't believe that you signed it. Now, Mark Erickson has spent 5 years claiming that he told his client not to sign that document. So it comes down to whether he signed it against legal advice or whether Mark Erickson didn't give him any legal advice and failed to protect him. And the jury is going to have to decide who they believe, Mark Erickson, the super lawyer, or if they're going to believe this 81-year-old man who has a hard time staying awake in the afternoon, who's not a very big guy, and who is, he could be viewed as either empathetic or pathetic. And so whether he is a good guy, a bad guy, none of that matters. Whether he is good in his business management or his love life or whatever, none of that matters. It's not relevant. The only thing that is relevant is whether or not his attorney protected him. So now let's talk about what the judge has done to make it harder for the former client. She first, it's Judge Sabin, and she first threw out that motion in limine. She said she granted it for Mark Erickson and his attorneys Brad Benning and Bruce McLeod. And the motion in limine said they can't talk about private judging at all. So they couldn't talk about how he put his client into private judging, how much he was paying the private judge, which I think it was about $25,000, which is actually inexpensive. And private judges make money on wins and losses in different cases. So $25,000 is not that much money for that. So when they threw out that motion in limine, that was a lot of things that Mark had done that, hi Real Jingy, nice to see you. That was a lot of, we see geese crossing. I'll show you the little geese crossing. It's kind of cute. You see them? Let me see if I can zoom a little bit. Geese crossing at the courthouse. Nope, there they come. Here they come. Those are not Canadian geese. Those are Silicon Valley geese, people. So I don't know where they come from. So the judge threw that out. So imagine this is a private judge related case. That was part of the fraud, and the judge threw that out. And that cripples the plaintiff's case pretty significantly, but they kept going. And the next thing, the judge threw out the fraud claim and the punitive damages claim. Again, clipping the wings of the plaintiff. And these are the things that the judges can do. They have the discretion to do this out of the eye of the jury. So the jury thinks the judge is the great person sitting there, but they talk about these things when the jury is not present. So the jury doesn't know all of this has gotten thrown out. So the motion in limine was granted, clips the wings. The no fraud and no punitive damages clips the wings. And then the next thing is, whoever's talking about my geese, sorry. They aren't Canadian geese. I'm pretty sure they're from Silicon Valley. So the judge does other things too. Says things about the attorney. The other big thing that a judge can do, because we underestimate what judges do in these cases, and this is part where we've talked about hometowning. Hometowning is when the attorneys from a local courthouse get a better benefit in court because they know the judges. They go out to cocktail hour with them. They had a little event here a few years ago. We crashed. It was called Whiskey and War Stories. I went with an ex-prosecutor's wife, and we sat at the bar and blended in and then just watched that and photographed that for a little bit. But it was before I was really videotaping everything. But they have their little clubs, they have their little groups, and they get to know each other. And if they like these attorneys, it's like having a favorite. When you have a favorite child, you may not even be mindful of what that looks like to the other children and how your bias, or if you're angry at one of your kids at one point in life or whatever, you don't know how that looks. You have the discretion as a parent to have a favorite or to like one of your kids at one time more than another. But when judges do that with attorneys, they can really influence how the case goes. So this judge very much was ruling in favor of Mark Erickson and his attorneys, granting them money on the objections. We're going to tally it up later, but when a judge constantly rules for the benefit of one side on the objections, that also can influence. It's because a jury isn't really sure what they're hearing when they hear objection, and then they give their little list. And I did post in my community section lists of kinds of objections. Hearsay, compound, whatever it is, you'll hear the attorney say that. And if the judge overrules the objection, the question's getting answered, and if they sustain it, the question is not getting answered. So then all the jury hears is the question, but not the answer. And that might be puzzling to a jury too. So we've been through this trial. The other thing that was a little bit prejudicial to the plaintiff in this case was that the Judge Pennypacker was the calendar setting judge, and I'm not a real fan of Judge Pennypacker. She does a lot of things. She's a Gavin Newsom appointed judge from 2018. She's the daughter-in-law of Phil Pennypacker, and just in watching her cases, she recently ruled when somebody tried to disqualify her. She said, "Oh, I'm just a calendar setting judge. I'm not going to leave." And she didn't get off the case. And that was a case involving Nicole Ford. And then she granted a motion for Nicole Ford. So she wasn't just a calendar setting judge. So judges really are the ones that can influence the direction of the case. And attorneys have to work around that. They have to improv, kind of like a journalist standing outside the courthouse. We have to improv. We're waiting for the jury to come back on a decision. I'm getting some text messages. I've heard what's going on inside that courtroom. I'm listening to what the jury is hearing and trying to, but I decided I didn't want to be in that courtroom because I didn't want to be swayed by anything. I wanted the jury to make their decision, and then later we can go back and read the transcripts and try to decide why they might have ruled the way they did. I'm going to show you more Silicon Valley geese. Ready? There they are. Oh, that was some attorneys I probably should have got. Look at, it's a whole flock right now. Okay, so what happened today, oops, you don't need to see me that big. What happened today was that they did a cross-examination of Mark Erickson in the morning. The plaintiff, his former client, testified a little bit, and it was all about whether or not he had a crush on Lisa Morey, the paralegal, which was ridiculous. And they never even talked about Lisa Morey going to work for the other firm. But the judge had talked to the attorneys for a while, so what we don't know is were the attorneys told they couldn't talk about certain things. And that is another thing. The geese are now causing a serious traffic backup over here. They think honking at them is going to work. It's not. And so that happened in the morning. It went a little longer. The jurors didn't get a break. Then they went out for lunch. Here, we'll catch these attorneys. I'm going to flip it around. We'll get people. So now the jury is in. They're listening to closing arguments, and that's when the attorneys wrap up everything that they've been doing. And they will hear the attorneys tell them what they told them. By the way, this courthouse is notorious for that. This is common. When attorneys go to court, these are the boxes that they bring into the courtroom. They've got their exhibits, their binders, and getting in and out of this courthouse is really difficult. And I've seen some older people really struggling with that. But that is not uncommon. So that is a trial. Usually you can see what the trial is by the names on the boxes. So let's get back to our jury. And so the jury is listening right now to the closing statements of the attorneys. And the attorneys are going to wrap up. It's like those English classes that you took where they told you when you write a story, you have to tell them what you're going to tell them it, and then you tell them what you told them. And right now, the closing arguments for the attorneys is what they are wrapping up, telling the jury what they told them. They're telling them that, look, this is the evidence that we presented. this is what you were told, this is what you heard the witnesses say, this is what you heard Mark Erickson say, and that's what they're listening to. And they're going to mull that around. It's 4:09 right now, and so whoever just said disability, handicap, accessible, no, this court, it's funny that you say that, because I actually had an elderly attorney that had to get up those stairs, and it was excruciating to watch him, and I asked if there was a handicap access, and if you look, the only handicap is you have to go around to the rear of the building, no parking back there, and so you have to get all the way back there. So I'm gonna wrap up what we're doing here on this, and then I need to tell you what else is going on at the courthouse, because we're covering, I told you we were gonna do 3 things today. And so they are wrapping up in closing statements right now, and they are going to, they're going to decide. The jury probably won't deliberate today, but once they wrap up closing statements, probably around it's 4:10, and I think the plaintiff's attorney was giving their closing statements, and I think then Mark Erickson's attorney will give his closing statements. And then it'll be 4:30, and so the jury will probably be dismissed and come back tomorrow and deliberate. And then everybody waits for that phone call, just like on television, when the jury is in and what happened. And so when that phone call comes, we are going to get the phone call, and we will come down here so that we're here and can report on what the jury decided. Oh, the other thing that I wanted to talk about, not only does the judge have the ability to rule on these motions in limine that keeps information from the jury, they can rule on the objections, but it was the scheduling in this case that was really a problem, because what happened in that was the Judge Pennypacker, assigned the case to Judge Izard, who has ruled in other malpractice cases. She's a pretty good judge, and we've watched a lot of cases with her. She's been fair, she's even-tempered, and she doesn't seem like she's trying to bias or do something unfair for one side. But Judge wasn't available to start the trial until the Thursday of that week, and Mark Erickson's attorney said, well, but I have a vacation and I have to make my vacation. And so the judge granted another judge, and they put it in front of Judge Sabin. But Judge Sabin, even though she started a day earlier, she only did 2 days, then gave them Friday off, then gave them Monday, Tuesday off, maybe Wednesday. They went again 2 more days, and then they had a whole week off because of Mark Erickson's attorney's vacation, and then they came back today after Labor Day, and they are scheduled to be here all this week, but unless they take a week to deliberate, they'll probably be done tomorrow. But think about that. This is a malpractice case, and if you were a jury sitting there listening to all these court documents and divorce case drama, that's a lot of weeks of your life. It's not a murder trial, it's not a car accident, it's not anything that's huge, but that is what our legal system does. And so judges in scheduling the cases can piss off the jurors, they can bias the proceeding with their orders and their motions in limine and that kind of thing. Okay, so we're waiting till tomorrow, and I'll come back tomorrow. I've got one more thing I'm doing tonight, and I'll do one more live stream tonight because it's really important. So remember, this morning we were talking about the code enforcement case involving a woman named Lindley Hogan. And when I walked into that code enforcement trial, and my videos on that have been a little slow banned, when I walked into that trial, the code enforcement hearing, it just felt like a private judge hearing. It didn't feel right. It felt like a kangaroo court. And then I found out that the administrative judge in the case, Jeff Blum, was he was a private judge and a divorce attorney. So now you think about this. We're talking about code enforcement and signs and property issues, and we give a family law attorney who works as a private judge to preside over that case. Well, he made some disclosures to Ms. Hogan that were not in the records that they gave me. So I asked for them. And by then, Jeff Blum must have figured out who I was and what I was reporting on. I sent him links to some of my reporting, and he shortly thereafter told me not to contact him. And it is interesting when judges or attorneys tell me they can say no comment or they can answer my question, but when they say, excuse me if that went in the microphone, I'm sorry. It is very windy out here and my allergies are kind of cropping up. So he told me not to contact him again, but here's what else happened. The case is assigned. She has a lawsuit in addition to this code enforcement. Thank you, who said bless you, Cabo. And so Lindley Hogan, in addition to her code enforcement, she has a lawsuit against 2 elected officials in Gilroy, a Ms. Risto and a Rob Moore, but also this man named Lee Faggett. And Lee Faggett runs an organization called Democracy Tent Los Gatos. And he wrote a declaration in the lawsuit trying to slap the lawsuit. That means throw it out of court as protected speech. And he wrote a declaration, signed it under penalty of perjury, that Democracy Tent in Los Gatos was a nonprofit. And so whoever said it did, and bless you. I'm really sorry for that. I couldn't control it. I should have thrown my microphone out. And so I looked for, when you're investigating a nonprofit, and I learned this from our work on Women SV, that DV nonprofit that was a sham, that you can look up the tax returns of nonprofits. You can see who's on their board, how much their founder gets paid. And so late last night, I submitted a media request in the case. And because I found out that Mr. Blum had disclosed to her that he was friends with people running this democracy tent that she is suing. And that seemed like a conflict of interest that was a little uncomfortable. And so after that happened, I decided to do a media request. There's going to be a hearing tomorrow on whether or not they're going to throw it out. And so tomorrow we'll be here because there's that hearing at 9 and the jury will also be deliberating in this case. So we've got 2 cases going tomorrow that are kind of critical, and I've done media requests for them. But here's the best part about Democracy Tent. I emailed Mr. Faggett and I asked him for his tax ID number so I could look up their tax returns and their information on the IRS website, because I couldn't get it by just putting the name in. And he emailed me back today to say that they're not a nonprofit. And I said, well, why did you say under penalty of perjury that you were? And he said, oh, that was a mistake. So this is what we've talked about before when people say this is a mistake and this is an intentional or willful act. And Mr. Faggett has, in support of a motion to throw the lawsuit that he's involved in and 2 elected officials are involved in, has not just made a mistake, but he's made a serious misrepresentation that arguably could be perjury. And so I started emailing about that, and I copied all the attorneys on it. I submitted the media request. I did not submit that to the judge, but I did submit some information to the judge on emails I got from Mr. Blum. And those emails were Mr. Blum, who was acting as the code enforcement officer, trying to persuade Ms. Hogan to dismiss her lawsuits against someone he already said he knew and was friendly with, and that he does a lot of work for the town. He's on the commission for the seniors and people with mental health issues. So when we start to look at these relationships, we all know there are conflicts of interest. And a judge, I did a video on that, it's got slow views on it for the reasons that are self-evident. But when a judge has a conflict of interest, whether it is financial, social, or personal, the people involved in the case and the attorneys, especially out-of-town attorneys, have a right to know. And once they have those conflicts, they're supposed to disclose them. And then they can add, but I still think I can be fair. And if a judge does that, there's very little you can do about it because they have the discretion to decide to when to go on or off a case. And so I thought it was really interesting that we never see judges disclose anything. We see people lying in court in a way that is not just a mistake or an accident, and nobody ever does anything about it. Police don't do anything about it, the judges don't do anything about it, and district attorneys just never prosecute it. So that's the kind of thing that we are seeing in this related case. And again, it's about private judging. Mr. Blum has a website where he promotes being a private judge and a mediator. He's a family law attorney. He's ingrained in the Los Gatos community. He writes for the Los Gatos, and he is also a code enforcement officer, and he tried to justify that it was no problem to me by telling me that he does it on a volunteer basis and doesn't get paid. Well, sometimes you don't need to be paid money if you're getting a better political or long-term benefit, or business as a private judge in another way. So those are the things that we're going to keep covering. And I've been on 35 minutes. If you listen to both my live streams today, we've spent more than an hour together. And that's a long time. So it looks like it's 4:20, and it looks like maybe some of the jury is being dismissed from the courtroom right now. And so we're back and do the rest of our work and get ready for tomorrow. But first, if there's a meeting in Los Gatos today, I'm going to go and make some public comment on that. And I might do my third live stream like I did last time. So I really appreciate it. For whoever just asked, do I have a Cash App? I have Venmo, I have PayPal. It's in my links on most of my videos. You can find it in the description box. And I really appreciate everyone being here 2 times today. And you might just get a third if you're not sick of me yet. So thanks. We're waiting for the jury to come back. It looks like it'll be tomorrow. Appreciate it, everybody. And we're going to talk about suing dirty divorce attorneys that are related to private judging and the judges that get in the way of that. Okay? Thanks.